Good morning. Edward Hugo, of Hugo Parker for Foster Wheeler Appellee. I'd like to begin my argument following up with counsel's argument regarding the inapplicability of the consumer expectation test. And I want to emphasize a theme here. It's common sense. So let me start with a Navy sailor, because that was the plaintiff in this case. A Navy sailor who is solely trained by the Navy and completely controlled by the Navy under orders of the Navy to maintain a warship boiler with the required Navy procedures and the required Navy materials. And he is under those orders with the threat of demotion or even imprisonment for failing to follow those orders without question and to the letter. That is not an ordinary consumer. And if we apply the filter of common sense now to the warship boiler, we have a warship boiler that is assembled pursuant to mandatory military specifications, never placed in the stream of commerce. It's extremely dangerous and extremely complicated. That is not subject to strict products liability. And to answer the question about burden, it's their cause of action. They have the burden to prove that this product, and I'm using that facetiously almost, is subject to the test. They failed, including a failure to show that it was in the stream of commerce. It's just simple as that.
So your position is that we're not entitled to the jury instruction because the evidence didn't support it.
100%.
And to my question to counsel was, what evidence? Or I guess there was no evidence. Like if there was, like I said, a collaboration, if this item was sold to a private business, I'm sure I would have heard that.
Zero, zip, nada, and none. They put on nothing. Absolutely nothing. And don't be confused.
I think they did put on actually some evidence, since you have 7 minutes left. I think they did put on some evidence of some collaboration and of this. There's components and then there's components, right? This was not a Kenmore dishwasher. But I think that goes to Judge Liberty's first question about whether there wasn't so much collaboration that this was truly something built to spec as opposed to a product regularly introduced.
It was 100% built to specifications, and their expert, Arnold Moore, specifically indicated that every one of the asbestos-containing products associated with the boiler, that's the insulation, the gaskets, and packing, were all specified by the military specifications.
But doesn't it work to your client's favor that there's some evidence in the record that there was collaboration with the Navy engineers about how, or naval architects about this particular boiler?
Yes.
I think I'm not trying to get you hung up. This isn't a trick. I think in response to Judge Liberty's question, you said there wasn't any collaboration. I think there is some indication in the record of collaboration, and I thought that would have worked to your client's benefit, so I wondered if I missed something there.
I think I misspoke or you misheard. I don't believe I said there was no collaboration.
Maybe I misheard. I thought that's what you said, but you've cleared it up. Thank you.
My client is the servant to the government. In other words, the government told my client what to do, and my client cooperated by assembling a product, a Navy warship boiler, not any other boiler, that was on that ship.
The collaboration, and just to follow up on that, it could be your client's expertise saying, well, maybe if we do it a little bit differently, we could do it more effectively, or the part will work better. I'm not necessarily saying that any collaboration whatsoever would go to the jury.
It wouldn't. And the evidence is that the government specified the products, and this is all in the record, that the government had inspectors at Foster Wheeler's facility to make sure that the products that it purchased were in fact provided by Foster Wheeler, that when the products were shipped to the shipyard, the government inspected them, that when the boiler was erected on the ship as it was being built, the government inspectors were there inspecting the boilers, that when the boiler was actually turned on and there were sea trials, the government was there. The government was there the entire time, and their expert conceded that if any part of that boiler did not meet the specifications of the Navy, that boiler would not be on the ship. Since I have more time, I'm not going to use it all, but I would like to turn my attention to the unavailability of punitive and non-pecuniary damages in a maritime case alleging strict products liability negligence. We get into the Wayback Machine and go back in time to common law, and we look and see whether those damages were traditionally available or not. The answer is a resounding no. That's practically dispositive of the subject, but pursuant to the requirement of the Supreme Court in Miles versus Apex Marine, we look at the Jones Act to determine whether or not those damages are available under those allegations in the Jones Act. They are not. That is dispositive. Those damages are not available. The district courts throughout California are faced with this issue, and my client is, since the pleadings are always the same. Judge Wu ruled correctly here in the central court, as did Judge Fitzgerald. Judge Battaglia in the Southern District ruled the same. More recently, Judge Gilliam and Judge Lynn in the Northern District ruled the same. It is worth a published decision that those damages are not available under maritime law for cause of action and strict products liability and negligence.
Why wouldn't we rely on the alternative ruling, which is that the district court reached, where he said the point of punitive damages is retribution, right? It's to establish a precedent, and there's no outrageous conduct here, and there wouldn't be any deterrent effect because the Navy no longer uses asbestos, and he went on, as you know. I'm reading from ER 6. Why wouldn't that be sufficient rather than reaching this question of law?
Because the allegations and cases that come forward thereafter are going to vary in terms of time. There might not be such a time gap. The company may or may not be in business, may or not be in business. We don't need to reach that. As a matter of law, non-pecuniary and punitive damages are not available in maritime cases based on allegations of strict products liability and negligence, period.
We don't typically reach and make new law in cases where we don't need to, is all I'm saying. And the court, that's why I looked to see if the court, relied on both factors. And I think he did. Make sure, do I have that right?
100%.
Okay.
But Judge Fitzgerald, Judge Battaglia, Judge Lynn, and Judge Gilliam all made rulings without taking that second step. It was not based on whether or not there was misconduct that needed retribution or there needed to be punishment. It was just as a matter of law, those damages are not available. That's why it's worth your time and effort to publish a decision that clarifies that.
Okay.
Thank you very much. Appreciate the time.
Thank you for your argument. You have a